Hello everyone, I am CS Pitre and welcome to the fourth lecture of our lecture series on company law. Today we are going to continue with our previous videos topic, that is types of company, and this is the part 2 of it. So let's start. Today's first type that we are going to discuss is one person company, and as the name suggests, it has something to do with having only one person. Before I explain this type, let me tell you how this type was introduced in Companies Act 2013. So we need to understand the object that in 2005, when J.J. Irani Expert Committee report was published, at that time in that report it was specifically recommended that there has to be some kind of company that will enable even small businessmen and small entrepreneurs to come and establish their own companies and perform business operations, because that way they come into this sophisticated mainstream business entities, and that is why this type of one person company was introduced in Companies Act 2013. Section 2 subsection 62 of Companies Act gives us the definition of it, and it says one person company is a company which has only one member. Unlike any other types of companies that we have studied till now, we have seen we always required minimum 2 members, right? However, here it is unique thing that even with one person, one member, that this company can be incorporated. Now, what is so unique about this one member? This person has to be a natural individual. So it has to be a human being like you and me. It cannot be any other company incorporating another OPC or any LLP incorporating OPC. That individual has to be Indian citizen, and that Indian citizen has to be resident of India. What do we mean by resident of India? He has been residing at least 182 days in previous calendar year. The important thing to remember here is calendar year. Okay, so in previous calendar year, if he is staying in India for minimum 182 days, he is a resident. Now we have understood who can be a member. Let's quickly understand the another thing that is required, which is related, is nominee. So when the person incorporates OPC, at that time he has to give the name of a nominee. Now why we need nominee? Because it's a company, it has perpetual succession. Now in case the person who is a sole member is in some kind of incapacity to perform this business of company, to enter into a contract, let's say he's dead, or he has become insane, or he is barred by law to enter into contract or act as a director or member, etc. In that case, this nominee will step in and act as a member, right? It is also unique about one person company that it is called one person because unlike any other companies, it can have only one director. Now, if we talk about private company, we require minimum 2 directors. If we talk about public company, we need minimum 3 directors. However, here, only one director is enough. So, tomorrow if I want to form my own OPC, I can be the sole member. I can appoint someone else as director, or even I can be the sole director, and I can continue having the benefits of having a company. So, this is a type of organization where you need only one member, one director. This member has to be a natural individual, citizen of India, resident of India. It requires nominee. Now, when we name this nominee, the consent of nominee is important. He should give consent. He should agree to act as nominee, and no minor cannot be appointed as a nominee for a simple reason that minor cannot enter into a contract, and he cannot be held liable. So, and of course, why one person company is preferred? Because it has way less compliances than any other type. Like I already said, we require less member, less directors. The total number of meetings to be conducted is significantly less. Even there are many exemptions given with respect to filing of documents, signature on documents, etc. Another thing to know is one person can form only one OPC. even one person can be nominee of only one OPC. This is important, otherwise tomorrow I will form multiple one-person companies and always avoid compliances because each OPC is exempted from compliance. That shouldn't happen. So one person can form only one OPC. However, with these advantages come some restrictions. These are: OPC cannot be a Section 8 company. We will discuss Section 8 company later in this video. However, let's understand right now, Section 8 company is a company just like a non-profit organization. Its sole objective is not to earn profit, but to do some charity work. So, one-person company cannot be a Section 8 company. One-person company cannot make non-banking financial investments. One-person company cannot invest in securities of other company. It cannot buy shares, it cannot buy debentures, any other securities for that matter, and it cannot convert in another type of company within 2 years of its incorporation. Within 2 years of its incorporation, however, it gets automatically converted in private company even within these 2 years if it exceeds its paid up share capital to more than 50 lakh, or its annual turnover is surpassed beyond this amount of 2 crore rupees. So 50 lakh rupees paid up share capital and annual turnover of 2 crore rupees. If this OPC exceeds this limit, then it automatically gets converted. So this is all about one-person company. Now let's see another type. The next type is small company. Now section 2 subsection 85 gives us the definition of small company. It is always a private company, it cannot be a public company, and its paid up share capital is maximum 50 lakh rupees and its turnover as per previous year profit and loss account is maximum 2 crore rupees. So these are the maximum limits. However, central government by issuing a notification can increase this limit. Up to what? This 50 lakh can be increased up to 10 crores and this 2 crores can be increased up to 100 crores, not more than this. Okay, but right now this limits as per the definition is this. Why small company is given a special status is because it requires very less compliances compared to other types of companies like any other normal private company or public company. They have way more compliances than small company. The same logic of OPC is here that we want small businesses to flourish and they should not be burdened with a lot of legal compliances, especially when their operations are small, and less compliances will be enough for them. That's why this concept of small company is there. However, there are restrictions to it. A small company cannot be a holding company or it cannot be a subsidiary company. We have already discussed holding subsidiary in previous video. Small company cannot be a Section 8 company, just like OPC. And small company cannot be a company which is governed by special act. Now we have already discussed statutory companies which are incorporated by a special act of parliament and that they are governed by that. So a small company cannot be that kind of company. It cannot be a company governed by a special act. So this is all about small company. The next type of company is Section 8 company. As we have been referring to it in previous two kinds of company, Section 8 company is a company with charitable purposes or the purpose of social welfare. Now, this same type of company was mentioned in earlier act under Section 25. So it used to be called as Section 25 company. In Companies Act, the mention of this kind is given in Section 8. Therefore, we call it as Section 8 company. Now, what it says is any person or association of person form a company with the object of, and they have given a list of things, the object of promotion of. So these people can form company if they have the object to promote commerce, science, arts, education, research, sports, social welfare, religion, charity, protection of environment, and any other. So any other means not exactly any other, something in these lines only. So if any person or association of person form a company with the object to promote these all things, and their intention is to apply whatever profits they are going to make in promotion of these objectives, then they can register a company under section 8 of Companies Act, and it has some own advantages to it, we will discuss. However, what is important to understand here is they have mentioned the word person or association of person, and there they have nowhere like given the definition of what do we mean by association of person. So the association of person can be any business or any organization, whether it is incorporated or not. Even surprisingly, in section 8 subsection 3 they have mentioned that even firm can be a member of section 8 company. Strictly speaking, partnership firm does not have its own separate legal existence. Therefore, it generally cannot hold shares of the company in its own name. However, section 8 subsection 3 specifically allows that. So this is this unique thing about section 8 company to be remembered. Now, because the intention of the company is to apply the profits earned by it towards the promotion of all those things that we discussed, it is prohibited on payment of dividend to members, because the profit is to be used for other purposes. It cannot be distributed amongst members in the form of dividend. At the same time, what benefit section 8 company can avail is, generally when a company has to get itself registered, the name of the company needs to be suffixed by the words private limited or limited. So if it is a private limited company, at the end of the name of the company, the words private limited will be added, or if it's a public company, the words limited will be added, so that any person who's reading the name will understand that it is a private company, it is a public company, like that. However, section 8 company, after it is incorporated, can make an application to central government to give them the license to use and continue the name of the company and operations of the company without adding the suffixes private limited or limited, as the case may be. Why it is important? Because generally when we read the name private limited or limited, we immediately think of a company. Company means somebody who's into business. However, this type of company is not really a commercial company. Their objective is not really to, achieve profits at what cost. They are there for some charitable purpose. So they should be given this advantage of not adding these words. Okay. However, this license that central government gives, they can always revoke the license if government feels that this company is doing something in contravention to the provisions of the act. They have stopped using the profits for the purposes that they promised to use, or the central government, if the have issued the license with some requirements, and those requirements are not being fulfilled by the company, in that case central government can always revoke that license. Next important thing is, when section 8 company has to alter its memorandum of association, it has to take prior permission of central government. Now why so? Because when they incorporated the company under section 8, their objective was to promote any of the things like commerce, art, science, education, research, etc., etc. Now tomorrow what I will do, I will form section 8 company. I will mention that objective. Now the objective is where it is mentioned, it's mentioned in MOA, and I will just alter the MOA and change it into, doing commercial business of so and so thing. So the whole purpose of having a section 8 company is nullified, right? That's why if I ever have to make alteration of MOA, I have to take the consent of central government prior to that. Also, if any time central government feels that one section 8 company can perform better by amalgamating itself with other section 8 company who's doing similar kind of work, and together they can do better, then central government can amalgamate one section 8 company in another. Also, the amalgamation of Section 8 company either through central government or voluntarily by the members of Section 8 company can be done only in another Section 8 company having similar objectives only. The next type is foreign company. As the name itself tells us, it's a company which is incorporated outside India. So section 2 subsection 42 of Companies Act 2013 gives us the definition of it. What it says foreign company means a company incorporated outside India or any other body corporate which is incorporated outside India, but it has a place of business in India, either itself or through any agent. And that place of business is either physically or through electronic mode. Now let's discuss it one by one. So it is a company or any other body corporate like we have the company as a business organization here. Other countries may have their own types, right? So it can be a company incorporated in that country or any other body corporate in that is the type of business entity incorporated in that country, but it is incorporated outside India, but it has a place of business in India. Now the place of business means they are conducting some kind of business activity, earning revenue income through India. They are providing services, selling goods, something like that in India. And they are doing it on its own or through some agent. So even if they have appointed some agent in India and through that agent they are doing business, still they are covered under this definition of foreign company. And this place of business need not be only physical. It can even be electronic mode. So online, if they are doing some business in India, then also they are covered in foreign company. So they can have branch office obviously, or they can do it electronically. Like for example, business to business or business to customer data interchange they are doing, or they are providing some online services like online education if they are providing. Like there are many sites, Coursera, Udemy, etc. So they are providing online services, online education to Indian students here in India. So indirectly, and they are earning revenue out of it. So indirectly they have a place of business in India. The only thing is that is online. Then through agent, for example, these international airlines, and they are conducting ticket bookings in India through their agents. So they will be covered in the definition of foreign company. Another example would be our Indian company, Zee Entertainment Enterprise Limited. They have this number of channels that we see. They have subsidiary outside India. It's a foreign company incorporated by them called Asia Today Limited. This Asia Today Limited provides satellite company to Zee Limited, which is incorporated in India. So indirectly, this Asia Today Limited has a place of business in India electronically. They do not have it physically, but through electronic mode, but through satellites, they are giving services to India. So it is considered as a foreign company. The next type of company is Nidhi Company. Before we start with this type of company, let me tell you something about its objective. Now, we all must have seen kitty parties or these pots or what we called as bishi, in which many people come together. So there are some members, 1, 2, 3, 4, and they all collect some money. So they all contribute some money to a common pot. And whenever either of them is in need of the money, that money is being lent to that person. And that's how again, and that person of course has to return that money back to this pot. However, when he is in need, he always knows that he will get the amount from that pot to fulfill his necessity. The same logic of this bishi or pot or kitty that we call is applied to this type of Nidhi company. Now, this type is very unique. Section 406 talks about these types of company. What it says, Nidhi companies are the companies which have the objective of cultivating the habit of thrifting or saving money amongst their members. So their objective is to encourage the members of the company in order to save more money, and they can receive the deposits from members and lend the money to members, and that is their sole objective. And they cannot lend money to anyone else, only to members, and can receive deposits only from members. Nidhi Company is always a public company, and it is given that it must have minimum paid up capital of rupees 5 lakh. Till now, no other company had specific minimum capital requirement, but Nidhi Company has this requirement, and at the end of the name of the company, the word Nidhi Limited must be added, so that any person who's reading the name should get that this is a Nidhi Company. Again, the rules regarding this, that is Nidhi Rules 2014, gives a lot of requirements to be fulfilled by Nidhi Company. We will not go into depth of that, just understand the basic of what exactly is a Nidhi Company, what is its objective, etc. The next type of company is Dormant Company, or also called as inactive company. Section 455 subsection 1 of Companies Act 2013 tells us about inactive or dormant company. What it says, if the company has not been performing its business operations for last two financial years, or it has not been conducting any significant accounting transactions for last two financial years, or it has not filed its annual return and financial statements with ROC for last two financial years, it will be considered as an inactive company. Now, why a company would be inactive? Generally what happens, people do form a company, but there is a time before they actually start the business operations. A lot of arrangements are to be made for place, for machinery, etc. So during that period of time, the company is in existence, but not a lot of going on in that. The company may be incorporated in advance for some future project, or to hold some assets or intellectual property right in the name of company. In that, if that is the case, what has been advised is the members of the company can apply to register of companies to get the status as dormant company. That is a company which is asleep for a period of time. Now what happens when a company gets the dormant status? A lot of compliances are exempted for these kind of company, because it is not actually performing any kind of activities as of now. Now again, when it wants to perform the business operations and it is no longer dormant, it can just apply the ROC again and gets the status changed from dormant to active company. This is all about dormant company. The last type that we are going to study is called as producer company. The name is self-explanatory. Producer, the company of producers. Now producers means what? Let's discuss. Before that, just understand, after the new Companies Act came into picture with effect from 1st April 2014, Section 465(1) of it says that this act repeals the Companies Act 1956. So the earlier act was repealed by new act. However, it specifically made an exemption for its Part 9A. Part 9A of Companies Act 1956 talks about producer company. So even if we have Companies Act 2013, all the sections and all the provisions of earlier act, 1956 act, are still applicable to producer company. Now what is the concept of producer company? It is a hybrid of cooperative society and company. Producer company has members who are primary producers. Now what do we mean by primary producers? Primary producers means people who are involved in farming, animal husbandry, floriculture, horticulture, forest goods, etc. So these are the type of people who can be member of producers company. The sole objective of producer company is to promote the goods which are produced by its members. One of the examples of producer company would be Vanilla India Producers Limited. So all the members of this company are the producers of Vanilla seeds. I hope the concept of types of company is clear to you. If yes, then please go ahead and like this video. Also, please don't forget to subscribe to my channel to show your support and so that you don't miss any video that I upload hereafter. Don't forget to share this video with all your friends who may benefit out of it, and I will see you in the next video. Till then, take care. Goodbye.